All right, hi again. Welcome back. AttorneySteve Vondran here. Another great video for you, especially if you're in the area of file sharing litigation, as we are, peer-to-peer, P2P, and you're following these strike three cases, these Malibu media cases. This is tales from the trenches. This is what's going on now, okay? So basically what happened, for those of you who have been watching my videos, in the Ninth Circuit, we had the Cobbler case. This was the Cobbler, Nevada case. It was a big case. It caused a lot of problems for companies like Strike Three Holdings, who is an adult pornography movie company with their main titles being Tushy, Vixed, Blacked, and Blacked Raw. Okay, so these are their videos. And Strike Three, as many of you know, have filed thousands, not hundreds, not tens, thousands of lawsuits in the federal courts. And here's the way it goes, according to what's been told to me from counsel that I deal with in California, okay? We are licensed in California and Arizona. We are not licensed in Florida. We don't practice law in Florida, but I do want to point out what they are doing now. So this is my belief, my opinion, that because of the Cobbler, Nevada case, which covers the Ninth Circuit, which is a very big circuit, California, Nevada, Arizona, Utah, Washington, Montana, Idaho, probably missed a few there, but point being it covers a lot of ground. It's a Ninth Circuit case, Cobbler, Nevada, and it said basically that you can't just sue somebody saying that they're the holder of an IP address and that means that they're guilty of copyright infringement. The court said that alone is not enough. You need something more. You need something more. So I think, this is my personal opinion, I think Strike Three ran into some real problems with that. They did come up with some things where they were trying to find other movies that were downloaded and tie those into Facebook likes of the alleged defendant and the alleged infringer. And I think that was kind of hit or miss. We had some of those, and it seemed to me to be kind of hit or miss on what they had. So I think what's going on now that we see, and people are calling our office, I don't want to say phones ringing off the hooks, but we're getting a lot of calls from people who are going, what is this Miami-Dade County? Why are they filing lawsuits in county court? I thought copyright was a federal issue. And I say, well, it is. Copyright is exclusive federal court jurisdiction. So I'm with those people, and I'm wondering just what's going on here. I've had some conversations, communications back and forth with opposing counsel in California, the firm that handles a lot of these settlements, and we've been dealing with for quite some time. But they're doing this new thing now, and I want to show you. It's called, if you look up here, it's complaint in equity for a pure bill of discovery. Up here, as you can see, Miami County in and for Miami-Dade County, Florida. So this is in a Florida court. And let's just walk down the allegations here. Remembering, now, Florida's on the other side of the United States, on the eastern side. They're in a different judicial circuit court. But nonetheless, I think the effects of Cobbler are rippling through because, they're filing thousands and thousands of these cases between them and Malibu Media. It's, they are, I think, more than half, if not even more than that, of all the copyright infringement cases filed in the United States. So you have two companies really going to town here. So now we have this pure bill of discovery. Okay, it's being filed in Miami-Dade County Court. Okay, it's not even though they're saying right here, plaintiff Strike Three brings this complaint against unknown infringers. They don't know who they are, except in Exhibit 1 here. Through this complaint, plaintiff seeks to identify the name and address of certain internet subscribers. This is what we call unmasking. They want to unmask and find out your name and address so they can look you up and basically do an asset search, see what you're worth, see if you own real estate, that kind of thing, see if they can get a settlement out of you, whose IP address has been identified as infringing plaintiff's content so that plaintiff may bring a copyright infringement action. So they're telling this court in the county that we're seeking a bill of discovery here to unmask the identity of the defendant or defendants, we don't know, because we might bring another copyright infringement action. And that time, I suppose they would bring it in federal court where copyright actions are brought. So the plaintiff attorney that I spoke with tells me, he says, well, you know, we know with 99% accuracy. Now, I have an email to this effect. We know with 99% accuracy the geolocation of the defendants. Okay, I say, well, where's that? Well, California. And I said, okay, well, why don't you just sue them in California? Well, we're trying to make it not 99% accurate. We're trying to make it 100% accurate. And we do that by going through the Miami-Dade County Court, jamming up their courts, I suppose, so that we might bring a copyright infringement case then in California, like up in the Northern District, Bay Area, or down in the Central District, LA area, Orange County, where a lot of these cases are filed, okay? So my question is, well, why not just file there the first time, since you know that they're there with 99% accuracy? Boy, that's incredible accuracy if true. Why are you not just filing this copyright infringement action that you say that you may want to bring? Why don't you just file it where it should be? Well, maybe the problem is the cobbler case. I don't know. What do you think? Maybe the problem is the cobbler case. So here they are now going to a new court. Some may refer to this as forum shopping, through the use of a Florida attorney to unmask and get these names. Okay, here you can see Strike 3 is a Delaware company. They know the plaintiff is in California, let's say, in some cases. And yet they're filing out there. Okay, I see. This is interesting. You know they don't live in Florida. And I said, well, what about a motion to quash? Shouldn't they just file a motion to quash then in Florida since there's no jurisdiction there? Well, they could, but we could still go file a lawsuit here, is along the lines of what I'm hearing. Okay, so let's just continue. Defendants are unknown infringers using the BitTorrent protocol, an anonymous file sharing device, to obtain plaintiffs' copyrighted movies and distribute to others without plaintiffs' consent or authorization. Defendants are known only by their IP address. Okay, all right. An IP address is a number that is assigned by an internet service provider, ISP, to devices such as computers that are connected to the internet. Frontier Communications, here's the ISP here, is in control of each IP address and can correlate the name and address of the person subscribing to the internet account behind each IP address, enabling plaintiff to identify defendant's true identity. Defendants use BitTorrent websites to access, download, and distribute plaintiff's motion pictures that are accessible in Miami-Dade County. So apparently the movies are accessible in Florida. That's one grounds, I guess, that they're looking at, and accessed by Florida residents. But they know it's not a Florida resident in some of these cases. Now, some of them may be Florida residents, but the cases that call me, they're from California, wondering what's going on in Florida, just so you know. Court has subject matter jurisdiction over this because a pure bill of discovery falls within the equity jurisdiction of the county court, and the amount in controversy does not exceed $15,000. Now, that's interesting. So we often will get demands in excess of $20,000, $30,000. We've seen them as high as $50,000, okay? But here the